All rise. The Honorables, the presiding judge, the judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Thank you. Good morning and welcome to the Court of Appeals. We have one case on the docket this morning for argument. Epcon Homestead, LLC versus Town of Chapel Hill. Your panel this morning consists of myself, John Tyson, to my right, Judge John Arrowwood, to my left, Judge Jeff Carpenter. We'd like to thank the clerk and our marshal for being with us today. Are there any preliminary matters to come before the court before we get started? Okay, all right. Well, if nothing else, we'll hear from the appellant. Good morning.
Good morning, and thank you. May it please the court. My name is Jeffrey Rother, and I'm with Morningstar Law Group. We represent the appellant Epcon Homestead, LLC. I asked to reserve 5 minutes for rebuttal. Okay.
Clerk has that. Thank you.
The question before the court today is whether the trial court erred in its Rule 12 dismissal of Epcon's state law claims for the return of development fees on the grounds that they are time barred. And I respectfully submit the answer to that question is yes. We ask the court to reverse the trial court's order and remand for further proceedings. This case arises of Epcon's ownership and development of a residential real estate project in the town of Chapel Hill, referred to as the Courtyards at Homestead. Epcon's claims arise from over $800,000 of fee payments it made to the town in furtherance of affordable housing initiatives that were required for certificates of occupancy for the homes it constructed.
Now, when did your client obtain ownership of the property?
That's pleaded in our complaint, Your Honor. It was Epcon Homestead is a single-purpose LLC that was acquired the property, developed the homes after the issuance of the special use permit, but before development.
And what date was that?
If you bear with me for a second, Your Honor. It acquired the property in 2015 and 2016. That was alleged in paragraph 9 of our complaint. I don't have the specific dates with me, but it was acquired through 2 separate transactions. Epcon and its affiliates were involved in the special use permit proceedings. It was an applicant, but the Epcon Homestead did not own the property at the time.
But by 2016, they owned the property.
That's correct, Your Honor.
Why didn't their cause of action accrue on that date when they bought the property?
Because the claim that was brought here is very different than the claims that perhaps could have been brought at that time. The fundamental principle at issue here is that separate claims arising from the same event or occurrence may have independent limitations periods, and those limitations periods may accrue at different times. And that's not atypical, even when different claims have common elements. We're in the development, local government area here, but in other areas you see the same thing. A breach of fiduciary duty claim has a period of limitations of 3 years, but a constructive fraud, which is premised on a duty breach, is a 10-year period. And a breach of contract is 3-year statute of limitations period, but if you couple that with aggravating circumstances, you could have a statutory Chapter 75 claim. That's a 4-year period. And in some instances, claims available from the same transaction or occurrence accrue at different times also. The Register case, cited in our brief, the date on which an accident victim's tort claims accrued was different than the date on which its right to compel arbitration for uninsured motorist coverage accrued. Court in that case was very circumspect of the exact situation here, arguments from the insurance carrier that who's advocating for the expiration of an arbitration right on uninsured carrier coverage before it even could have brought that claim. And that's very comparable to the situation here. That principle is so important of independent claims accruing potentially at independent times because the town and apparently the trial court have spent a lot of time and energy arguing that a claim that we never brought is time barred when there's available time and we timely brought a separate claim for different relief. The claims that were asserted here are exclusively state law claims for the return of unlawfully exacted development fees. And there are two sources for that cause of action. One, statutory, Chapter 160A-363E, which has since been recodified as 160D-106, provides if a local government's found to illegally exacted development fees, it's obligated to repay that amount with interest. And also that principle is recognized under the common law. The Smith Chapel Baptist case from 1999 recognizes that when development fees are taken by a local government in excess of their authority or illegally exacting those fees, it's akin to a claim for money hadn't received. The equity balance is in favor of a refund of that amount, and it's been a recognized claim ever since then. We allege that the fees were unlawfully collected for three independent reasons, which I'll get to, but we need to focus on to respond to your point, Your Honor, we need to focus on the claims that were actually asserted here versus those that aren't at issue. Could Epcon have filed suit before paying its fees, before maybe even obtaining its special use permit, and asked that the court strike the ordinance or to strike a development condition from a permit? Sure, it could have, but that's not what's at issue in this case. North Carolina law provides an independent cause of action, an independent remedy for a plaintiff to recover unlawfully exacted fees. The town has defended this case as if we're seeking injunctive relief, if we're seeking prospective relief, which is not what we were doing here. Put simply, the town is attempting to apply limitations periods relating to claims for prospective relief, and the trial court, I believe, adopted that reasoning. I understand we're in de novo review, and the trial court's reasoning is not necessarily critical here, but if I understand the trial court correctly, it says that any claim for a refund trying to recover illegally collected fees is based on the unlawfulness of the underlying ordinance here, LUMO section 3.10. And Epcon, what I understand it to be saying is, Epcon, you can't do that now because you didn't challenge the validity of the ordinance back at the time of the special use permit proceeding. As in, you can't claim that the fees were unlawful or unlawfully collected because you didn't challenge the validity of the ordinance before you even paid those fees. So the underlying issue in this case, the fundamental issue, I believe, is the timeliness of Epcon claims now, recognized claims under North Carolina law for the recovery of unlawful fees, tied to the limitations period for when it could have brought a different claim for prospective relief, whether it's to strike a condition, to attempt an injunction and invalidate an ordinance. And the answer to that's no for multiple reasons. As I stated, the general principle is that limitations periods operate independently from one another. Statutes of limitations bar claims, they don't bar elements of claims, and they don't bar arguments. The fiduciary duty example that I raised, it's a 3-year statute, but constructive fraud's 10. If I file suit after 6 years, that doesn't mean I may not be able to bring a claim for breach of fiduciary duty. But that doesn't mean I can't argue that there was an underlying breach, because that relief is still afforded under a 10-year period under constructive fraud.
You've used two terms kind of interchangeably, claim and cause of action. You've mentioned claim. Judge Airwood asked you about a cause of action. In your view, is a claim and a cause of action the same thing?
I've been using them interchangeably, Your Honor, and I think that's
you
right.
also mentioned earlier that different causes of actions accrue at different times, but they arise from the same claim, core facts, right?
Exactly. And I may have a same underlying complaint or same underlying set of facts and circumstances, but North Carolina law recognizes independent causes of action.
Right.
And the statutes run independently for each of them.
All statutes and limitations are statutory. You agree?
Correct.
The statute uses the language cause of action, not claim. That's why I asked the question. In your mind, is there a difference in the two? Because the statutory language is cause of action, not claim.
Which statute are you referring to, Your Honor?
The applicable statute in regards to statute of limitations for this case.
A claim to a right,
It uses-
I'm sorry. A claim for recovery of liability created by statute.
The statute begins to run when your cause of action accrues, is the language.
Exactly, and that's the point here, Your Honor, is that
We're using claim and cause of action interchangeably, and I'm not sure they're the same thing.
they're often used interchangeably because of, I can understand the use of the term claim as far as events of circumstances, your claim referring to an allegation. But if I understand your question correctly, causes of action are what the statutes apply to.
If you, does your claim, I guess the question is going to be, if the claim rises under the cause of action, or you can have different causes of actions based on common facts.
That's exactly the point, is that
So if a claim would arise out of one cause of action, to Judge Carpenter's point, would that bar any claims that would have arisen under that cause?
No, Your Honor. I think the law recognizes that the statute of limitations apply to causes of action. They don't apply to elements of causes of action. They don't apply to legal theories. Is that some allegations, some events and circumstances, different causes of action have overlapping elements, and regardless of what the underlying allegations are, the statutes apply to causes of action. And
So when did the harm accrue?
it depends on what harm you're talking about, Your Honor. So
What harm are you talking about?
the harm for which we are here today is the payment of the fees. Is the Quality Built Homes case, which I'll get into, recognizes that statute of limitations don't begin to accrue until the harm for which you're seeking redress until that occurs. So the Fourth Circuit talked about a constitutional harm, and it distinguished that between the harm for which we are here today, which is the payment of the actual fees. And what I was getting, when I was responding to the fundamental question, which is the basic principles that recognized throughout these cases also, that claims cannot accrue or even expire before you could actually bring them. What the trial court ruled and what the town is trying to have this court adopt is a standard where our recognized cause of action for a return of unlawful development fees, the time to bring that claim started and even expired before we even paid them, at a time that we couldn't have even brought those causes of action because they wouldn't have been ripe.
Well, you could have brought a cause of action that said, I don't have to pay them, couldn't you?
Correct. But that's an independent cause of action.
There would have been no payments. Isn't that correct? Under your theory.
If we brought a cause of action to invalidate the ordinance and to go through that process before development and successfully enjoin the enforcement of it, then yes, there would have been no payment of fees. But it goes to the underlying point. The statute of limitations don't require someone to get out in front of an injury. But the injury and the harm that we're talking about is the payment of these fees. With a breach of contract case, it could be very clear.
Well, why isn't the injury and the harm the requirement that you pay the fees?
I'm sorry, Your Honor?
Why isn't the injury or the harm the requirement that you pay the fees?
Well, I think the court has already stated in Quality Built Homes that there's a difference between knowing that the requirement is there for the fees to be paid and actually paying them, right? So in this case, when our permit was issued, it said $803,000 to be paid every seventh certificate of occupancy. There was no present obligation to pay that fee. A special use permit is a permissive entitlement. It gives me the opportunity to build a development in accordance with town specifications, but there's no requirement for me to actually carry through with that. And a lot of developers don't. They obtain a permit and they gauge the market, right? So there could have been multiple paths for this development. Epcon could have let the permit lapse. It could have sought a different use and got it rezoned. It could have sold the property. In all such situations, no fee would have ever been paid. So the harm that is at issue here is the payment of fees. And there was no present obligation or liability taken on by Epcon at the time that the payment was, or the time the permit was issued. And in
What about when
reality,
you built the first unit?
I'm sorry, Your Honor, I didn't hear you.
What about when you built the first unit?
When we built the first unit, first of all, the time at which we built the first unit is not alleged in the complaint. So that's outside of the operative facts.
Well, I'm asking you a hypothetical question.
I understand that, Your Honor. I think and that would require an understanding of what the obligations were to carry through once a permit, a home was constructed. And the same situation, they could have sold the property to another developer and never paid the fee. They could have attempted to stop development at that point and no fee would ever be triggered. And my point is that the harm didn't accrue until the fees were paid. And this principle is really no different than what has already been addressed in Quality Built Homes. I believe the court is familiar with that case, which involved a claim to recover water and sewer fees that exceeded the fee authority of the public enterprise statutes. And the reasoning behind that holding is just as important as the holding itself. And because in the situation there, what the court recognized is that at that time, at the time the Supreme Court had that case, this court had already held in certain contexts that a fee claim was subject to a 10-year statute. Point South Properties, Amherst Homes, and other cases. Town of Carthage argued for the application of much shorter statutes of limitations. The town of Carthage, like the town in this case, argued that a claim accrued when the right to maintain an action arises, right? They said they knew this fee was going to be coming forward. As soon as this ordinance was passed, everyone's on notice of that, and they had to bring that claim immediately. They can't try to recover the fees now. And the Supreme Court did two things in Quality Built Homes. First, relying on the continuing wrong doctrine, it held that a claim for the recovery of local government fees that accrues at the time the fees paid. And the court recognized that, yes, the Quality Built Homes in that case could have brought a claim for prospective relief. There's an ordinance on the books, and they knew it was there. They knew if they wanted to build a development, they would have had to pay those fees. But the plaintiffs in that case didn't bring that claim. They brought a fee recovery claim, which is an independent cause of action, as Judge Carpenter recognized. And the court said the nature of the wrongful conduct and the harm alleged in plaintiff's complaint rests upon the town's collection of the water and sewer fees rather than the adoption of the impact fee ordinances. Plaintiffs did not sustain any direct injury at the time the challenged fee ordinances were adopted. Instead, plaintiffs sustained the injury upon which their claims rest when plaintiffs were required to make the impact fee payments in order to obtain approval for the development proposals. The same situation's here, right? That in both cases, there was an ordinance on the books dictating what the obligation would be of the developer. In both cases, a fee was paid during the development process. The only difference here between Quality Built Homes in this case is that there was an intervening special use permit that stated the amount of the fees that were to be paid. And it's important to recognize—
Isn't that a large difference?
I don't think so, Your Honor, because of the way that the amount got there into the permit, right? These are legislatively imposed obligations. The town council, the town of Chapel Hill, was not there to determine whether there was some obligation that had to be there to meet other obligations in the town ordinance. It wasn't there to calculate or adjudicate how much of a fee or how much of a exactment had to be made for this development in order to go forward. It was not an issue adjudicated. All that happened with this permit, if you look at the permit, there are 100 conditions in it. The town listed every condition that had to be done under the sun, under the ordinance, without any of those issues necessarily being adjudicated. It would have been no different than the town sending us an invoice when the permit was issued, said, if you want to move forward 2 years from now, this is how much you're going to have to pay. And that's the important difference. I could understand your point if it was a standard that the obligation or the payment was dictated by quasi-judicial procedures, and there was an element of discretion to determine what Epcon would have had to have done for this development to go forward. In that case, if we were challenging the underlying decision-making or the reasoning of the quasi-judicial decision, and we somehow claim that there was an error in their decision-making process, I could understand that because that was the time to challenge the decision-making. Here, with this permit, there was no decision-making. The fees were legislatively imposed. All they did was say, okay, you got 63 lots multiplied by 15, and that's what your fee's gonna be in 2 years when you get there. So the difference here, I think, is a distinction without a difference, because we're in a situation where, just like in quality-built homes, the obligation was known and it was imposed by ordinance. Ultimately, that fee was paid down the road once development accrued, and as the court said, those claims accrue at the time the fee payment is made. The only difference here is that we have a permit that states what that obligation was going to be that was already dictated by ordinance. And it's no different than Bill Clark Homes. This court applied the 3-year statute of limitations to a claim that was paid within 3 years, but the facts in that opinion reveal that the plaintiff was invoiced more than 3 years before the fees or before the suit was brought. It's really no different because at that time in Bill Clark Homes, when they received an invoice for the fee, they certainly knew what the amount was going to be. There was certainly a clear line in the sand drawn by the local government as to what the obligation was. And the court still applied 3 years statute of limitations measured from the time the fee was paid, because that is the date on which the harm for which redress is being sought was accrued.
So if you get a building permit or a special use permit, has a laundry list of things you've got to do. Get a DOT access permit, extend water and sewer to the site, any of those, build sidewalks, whatever it is.
Yeah.
And a building inspector, or you get denied, let's say you get denied the DOT access permit. Would you not still be able to challenge the DOT's decision without saying you should have brought that claim when you picked up the building permit or the special use permit?
That's exactly right, Your Honor. If there's a condition, if I understand your question correctly, if I have a special use permit that says you need to get a driveway permit and work through road improvements for the public road outside the development, and I try to do that, and DOT says, no, I'm sorry, we're not giving you a...
DOT can't come in and says you had to challenge that when you were aware of that condition. You can't challenge my decision.
No, I think in that situation, DOT's policies are objective, right? So if I understand you correctly, you're entitled to a permit as of right if you satisfy all of the elements for providing it. So those two things run independently from one another.
We recently had a case involving the water system in Greensboro on fees.
True Homes?
Yeah, I don't think either one of y'all have cited that case, so it wouldn't be fair for me to ask you, but
If I understand you correctly, True Homes for City of Greensboro, is that?
I think that's the,
It's cited in our reply brief for a tangential point.
okay, so you do cite that. So is that applicable here?
I think we cited it for the proposition that in that case, in
It's on page 17.
yeah, that's 50. Yeah, the only purpose for which we cited that case, Your Honor, was just, again, the application of in these class certification contexts, the courts are consistently applying, certifying classes for classes of people or developers who pay fees within 3 years of which the date the suit was granted. And that's indicative, again, of this court and the Supreme Court continuing to recognize that the date of accrual is triggered by payment. And when we're looking at a class certification issue, of course, divergent
Tell us
factual
this,
issues.
you're here on a 12B6.
Correct.
Basically, we review that de novo.
Yes, Your Honor.
You get the benefit of all your allegations being treated as true, in light most favorable to you. So where did Judge Baddour get it wrong? Did he just pull the trigger too quick? Should we have waited for a 12C? Should he have waited for a summary judgment? Where's the issue?
I think we gave, I think our complaint had a certain amount of candor to it. We knew when we filed this case that this was going to be an issue that the town would raise, and we didn't hold anything back, right? We could have came in and said, we paid this fee, it's due back to us, it was illegal, give it back, and we wouldn't be here, right? That would be a summary judgment issue. We put forward the history of how we got here. I think where Judge Baddour erred is assuming that, or finding that a legal theory or an element of a claim cannot be pursued, and that it becomes barred by a statute of limitations. We are not bringing a claim to challenge the validity of the ordinance. We're not bringing a claim to challenge the validity of a permit condition. We're bringing a recognized cause of action.
You kind of are. It's an ancillary attack on the ordinance, isn't it? You don't want to, you're not saying you need to set the ordinance aside as it's unconstitutional. You're saying it's unconstitutional, we want our money back.
Exactly.
So it's a collateral attack on the statute.
It is, but the statute of limitations is there to prevent claims to challenge the validity, right? It is not a bar for ever claiming in the future that a claim is, or that an ordinance is unconstitutional or exceeds statutory authority. That is a principle that is well recognized in quality-built homes.
So yours is an as-applied challenge as opposed to a facial challenge?
It's correct, Your Honor. We're here only to get our money back. I don't know if that distinction needs to be made, because we are here for a claim to recover unlawful fees.
So let's say the tax collector sent you a bill that was more than what the actual tax is due. When do you have to challenge that? When you pay the taxes or when you were billed for them?
I don't know the exact answer to that, Your Honor, but I believe a tax claim accrues at the time that the taxes are paid for a refund of taxes.
So the timing of when they billed you for them is irrelevant?
Is irrelevant, exactly. And to finish, and I know I'm running short on time, but to finish.
Well, you have your rebuttal time.
And to finish the point is that where I think Judge Baddour erred is assuming that an argument is lost forever within a certain period of time. We're not trying to come in and strike the Land Use Management Ordinance Section 3.10. That's not our claim.
Well, let me ask you this. Isn't a statute of limitation of an affirmative defense? It has to be pled,
It
not
is.
proved. And so on a 12B6, that statute of limitation as an affirmative defense has not been asserted, has it?
Well, at 12B6, I believe the court has recognized that a 12B6 is a proper vehicle for a statute of limitations if all the facts necessary to decide that a claim is time barred are evident from the face of the complaint.
Does it have to be raised
I
by a motion on that day?
Yes. And I believe it was raised by a motion. But the point, what they didn't do in the motion, I don't believe, is identify the specific statute of limitations that are applicable here. And what Judge Baddour didn't identify in his order either is the specific statute that he was applying or identify the date on which it was accrued. So that is a fundamental gap, I believe, in what we have.
The town says it's 1-15 is the applicable statute. What say you?
Well, they say it's 1-393.1, and they say it's 1-54 and they say it's 160A dash, I believe, 364. There's several that the town have tried to apply here, all of which I've addressed most of them in our briefs. 160A-393.1, it was a new claim created in 2019. That it has a one-year statute of limitations for claims that are brought under that subsection. Put simply, we didn't bring the claim under that subsection, so it doesn't apply. Number two, it was enacted, we brought a claim. We brought our original claim within a year of it being enacted, so we were actually timely, if that's the applicable statute here, which we believe it's not. And third, this court has already held that 168-393.1 is not applicable to claims for the return of unlawful fees, and that's the Bill Clark Holmes case. As far as 1-5410, I believe, is the other, which is a one-year statute of limitations for claims challenge or cause of action challenging the validity of the ordinance, and that all goes to the issues that I've spoken about before, Judge Carpenter, which is that argument, I believe, has been taken out by Quality Built Homes, and we are squarely within the ambit of both the holding and the reasoning of that decision.
Do you have any summary you want to do at this time, or you want to reserve it for rebuttal?
I'll reserve it. The one thing that we haven't addressed, Your Honor, is the substance of the underlying claims as far as our allegations of the unlawfulness of the fees. I will happy to rely on my brief and reserve the amount of time for rebuttal unless the court has any other questions.
Okay, thank you. Any questions? Any questions? Thank you, sir.
Thank you.
Hear from the appellee.
Good morning, Your Honors. May it please the court, my name is Catherine Barber-Jones. I'm here with co-counsel Dan Hartzog, as well as Jim Baker, the Assistant Town Attorney from the Town of Chapel Hill. And we represent Defendant Appellee, Town of Chapel Hill, in Plaintiff Appellant's appeal of the Orange County Superior Court's order granting our motion to dismiss this suit. This case presents the question of whether a developer can request to pay a fee in lieu to comply with a development condition, go ahead and go through the approval process, build the development, and wait to file suit to challenge the condition of development based on the underlying ordinance being ultra vires or unconstitutional for more than 5 years after the development approval, and at least 4 years after the plaintiff acquired standing by beginning the purchase of the land subject to the approval.
When was the payment due? Upon completion?
So pursuant to the ordinance, it does not provide a particular payment due date. The ordinance provides that you build affordable housing. The payment in lieu has to be requested specifically and approved by the council. Within the special use permit, the town council allowed the 800-something thousand amount to be paid in installments where the deadlines were set up for a specific number of certificates of occupancy.
Let me ask you this. If he had originally planned to build 10, paid the fee for 10 and only built 5, would he be entitled to reimbursement for the 5 he did not build?
Your Honor, if Epcon had brought a case challenging the development condition, whether it was building houses or payment of the fee in lieu in a timely manner, a superior court could have granted that relief.
Okay, so when does the statute accrue? When the damage is done? When the injury is incurred?
Your Honor, the underlying causes of action in this matter relate to having this condition declared ultra vires or unconstitutional.
That's a facial challenge, is it not?
Your Honor, as the General Assembly clarified when it passed 168-393.1, it can apply to facial challenges of development conditions or as applied. So Your Honor, I believe the General Assembly has said, when we're challenging development conditions, we're in the same universe here for facial challenges versus as applied, and they accrue upon gaining standing.
Which statute of limitations is the town relying upon to sustain Judge Bedour's verdict or order?
Your Honor, the town's position is that the one-year statute for challenge of a zoning or development ordinance or a challenge of, a zoning or development ordinance which is set forth in 160A-364.1. That statute refers to 1-5210. So those are basically in the session law that we cited in our brief. Those were both updated at the same time.
Has that been recodified under 160D?
Yes, Your Honor. Now that it's in 160D, it is at 160D-1405, I believe, B. And, Your Honor, we also contend that because this special use permit was the result of a quasi-judicial proceeding, which the further we get from the recodification of 160D, it's harder to remember, but back in the original zoning authority statutes, councils were allowed to issue special use permits through quasi-judicial proceedings. And those are reviewable through a cert proceeding or through civil action for declaratory judgment, like the one plaintiff filed here. And the statute of limitations for those civil actions is found in 160A-393.1, I believe D, that it is cited in our brief. Your Honors, in its briefing and argument, plaintiff has made much of the fact that 160A-393.1 was adopted by the General Assembly in 2019. That is acknowledged in our briefing, but at the time, the General Assembly also said that they were clarifying the existing law, that section of the session law is a clarification, not a modification of the existing law. And so, Your Honors, we contend that plaintiff could have pursued a civil action or a writ of cert to the Superior Court of the special use permit had they believed that an unconstitutional or ultra vires condition had been imposed on them. And that is another issue that is argued in their brief, that the cert proceeding is only available to review the conclusions of the Board of Adjustment or whatever board undergoes the quasi-judicial proceeding. That has simply not been the case since 2009. The statute setting forth the scope of review in certiorari includes arguments that a condition or decision was unconstitutional or beyond the town's authority, ultra vires, in that review process. Your Honors, as we've noted, we believe that a one-year limitations period applies. That is only half of the inquiry when you're making a statute of limitations argument. The other half is, when does the claim accrue? We argue that it accrues upon the injury, which is the application of the development condition. The cases cited by plaintiffs almost all relate to water and sewer impact fee cases. The injury in those cases was the town of Carthage, or many other cities, unfortunately, exceeding their authority under 160A-314, which is among the public enterprise statutes that authorize towns to operate water and sewer systems akin to how commercial entities operate water and sewer systems. The statutory violation in that case was the source of the harm. It did occur during, the payment did occur during a development process, but the North Carolina Supreme Court in Quality Built and later courts courts quoting that decision, such as in Bill Clark Holmes, said this isn't a case about a development condition. This is a case about what a water and sewer customer is being required to pay and whether it's within the town's authority to charge it.
There was a case out of Brunswick County involving the payment of $600,000 for a sewer capacity fee that was paid, and the economic downturn of 2008, 2009 prevented there was no money to build because of lack of funds. And once the economy changed, the builder went back and wanted to proceed, having paid those capacity fees. Brunswick County said, no, you don't get credit. What did the court hold in that case? Do you remember?
Your Honor, I'm not familiar with that case.
Well, the court held that even though that was an express date by which you had to change or had to take advantage of those capacity fees, that the plaintiff was still entitled to prevail, notwithstanding an express date.
Notwithstanding, I'm sorry.
An express date in the permit conditions, you had to use them by a certain time. Is that, if that's a correct statement of the case, would that be applicable here?
Your Honor, I believe it would not. The permit in this case had to do with a development condition that was requested. Originally, the town wanted the plaintiff to build affordable housing. The plaintiff asked, can we please do this as a fee in lieu instead? We want to build a luxury senior living community with amenities that would make it impractical to price the lots as the ordinance calls for. This was not a fee that is assessed in every case on a fee schedule. This is a condition of development that plaintiff obtained special agreement from the town council to have instead of building differently.
Wait a minute, let me make sure I understand what you're saying.
Yes.
If the plaintiff had chosen to build quote unquote affordable housing, whatever that is,
Yes, Your Honor.
then they wouldn't have to pay the fee.
Yes, Your Honor.
All right, so, but they chose not to do that.
Yes, Your Honor.
And that's, you know, the fact that they chose not to do that means they were not taking advantage of an incentive. Is that correct?
I'm not sure I understand your question, Your Honor.
If they had chosen to build affordable housing,
Yes, Your Honor.
they would have had the benefit of an incentive of not having to pay the fee.
Your Honor, the fee wouldn't have entered into the calculation.
That's what I'm saying. There would have been no fee if they had chosen to build quote-unquote affordable housing.
Yes, they would not have had to pay a fee, except to the extent simply that in order to reach 15% of the development, I think there was a 9.45 units calculated, and you can't build 0.45 of a house, so that would have been part would have been paid.
It's a round up or round down. Okay.
Yes, Your Honor.
So was it a density issue here, or was it just a land cost, development cost issue, or do you know?
Your Honor, I believe price per lot is the condition mentioned in the attachment to the complaint, the staff report concerning the developer's requests.
So if the owner says, you know, affordable building may be nice, housing may be nice, but it won't work on the economics of what I pay for this land, would I have to grade it, I have to bring utilities to it, all the unknowns. I mean, are we penalizing people for not building affordable housing?
Well, Your Honor, the ordinance allows several different means of potentially complying with it. You know, one of them is this fee in lieu option. Another is donation of land elsewhere that could be used for affordable housing. And so I don't believe that the town is penalizing anyone. There are different options for coming into compliance with the requirement that new development in the town not cause an issue further on down the road for denser concentrations of affordable housing because there's just limited land left in Chapel Hill for new development. If you don't want dense concentrations of affordable housing, the theory, in the ordinance that's attached to the complaint is that you spread it out among new development.
Is there any provision in there, let's say they hit rock, or they hit a spring, or they encountered significant cost during the construction? Is that just something the developer has to eat?
Your Honor, in theory, they could go back to town council and request an amendment to the permit. The permit, is available through this quasi-judicial process, but it can be amended through the processes in the town's land use management ordinances as well. As mentioned at the beginning, if they believed it was unlawful or unfair from the beginning, they could have challenged it then as well.
Well, I guess they didn't know. I guess that's my problem is development is not a objective, absolute, this is what it's going to cost. You don't know what it's going to cost until you're in the middle of it. So if you're based on cost, you're trying to impose a fixed condition on variable conditions. That's the problem you got.
Yes, and I know that the last decade and a half have been very difficult for predicting development costs especially. There have been, at the same time, many different changes to the development statutes. We're dealing with a version that existed in 2019. However, the processes that are set out in the statutes and then adopted by the town in the LUMO are intended to tailor the requirements for each development to what the developer wants to do with it.
How did plaintiff get it wrong with relying on Bill Clark and Quality Built Homes? Why aren't those cases controlling here?
Well, in the first instance, they're distinguishable because they are water and sewer cases where the development ordinances don't apply because the source of the injury was from the water and sewer enterprise fee statutes, not from a condition of development.
Is that a distinction without a difference? They both involve the payment of money.
While both involve the payment of money, there are many different, it's similar to Fowler v. Valancourt. In Fowler v. Valancourt, there was a dispute over the applicable statute of limitations because the plaintiff had pled assault and battery, and the defendant raised the issue that it was by a public official. So was it the statute of limitations for assault and battery that applied, or was it the more specific statute of limitations for a violation by a public official under color of law? And the court said, well, there is a more specific statute here. That is what applies. Not necessarily assault and battery as the plaintiff has couched it in their claim, but we look at the underlying source of relief. And here, the plaintiff wants to have these conditions declared unconstitutional or ultra vires in order to obtain the relief that they're seeking under 160A-363. The fees have to be declared unlawful before they can recover under that statute. That statute is not a standalone. And so everything goes back to the validity of those requirements, whether facially or as applied. And because everything goes back to the validity of a zoning or development ordinance, it goes back to that more specific statute of limitations, the one-year statute applicable to challenges to development conditions. Your Honor, the North Carolina Supreme Court in Quality Built in footnote 4 said, we are not even touching whether this repayment occurs under 160A-363. That's not what this case is about. This court has previously commented on the adoption of that statute as being a vehicle to provide interest along with refunds of fees because And that case is China Grove 152, I believe in 2015, because the court had felt it was inequitable that in cases similar to what you brought up, Your Honor, a developer could pay money years before and then only obtain the refund many years later, but without interest. Under Durham landowners, they said there needed to be a statute allowing such interest, and the General Assembly reacted pretty quickly and adopted a statute that allowed interest along with the refund of the fees that had been declared unlawful. And so, Your Honor, plaintiff seeks declaratory relief in the first 3 causes of action in their complaint. They are challenging the validity of these conditions, and it is necessary to their relief under 160D-106 or its predecessor, 160A-363. It all comes back to an unconstitutional or illegal development condition. Another distinction in quality-built homes and later cases is that in those cases, the plaintiffs were not, or rather the statute of limitations arguments that the defendants were making were that the plaintiff should have challenged the ordinance as soon as it was adopted. There wasn't any discussion of standing, which the statute of limitations that we've been discussing, 160A-364, originally did require that the challenge be brought within 1 year of when the ordinance was adopted, but it has since been amended to refer to when the plaintiff has standing. The claim accrues when the plaintiff has standing. And among the clarifying amendments to the development ordinances in 2019 was a clarification of when a plaintiff gains standing to challenge a development condition. And that includes when they acquire an ownership interest in that parcel that had been in 160A-393, and it is repeated in 160A-393.1. Your Honors, we presented this case to the court as a case about the statute of limitations. I would like to address briefly plaintiff's arguments that the continuing wrong doctrine should apply because they were charged fees. And the town contests that characterization of what was done here. This was a case involving a single amount that plaintiff had asked to pay in lieu of building affordable housing, that the town council said you can pay in installment payments. But as the Middle District of North Carolina said in its opinion, and the Fourth Circuit agreed, all of these payments are partial installments toward a total that was determined in 2014 and that plaintiff learned of no later than 2015. It is not a continuing wrong. It is continuing ill effects from the original alleged violation.
Is it based on a per unit or per lot assessment, though?
So the requirement for building affordable housing is 15% of the units, and then
So it's a mathematical calculation based upon the size and density of the project, right?
the number of units.
So it's not a lump sum, it's the sum is a product of a mathematical formula based on a dollar amount to each unit. Is that a fair statement?
Yes, Your Honor.
Okay, so it's not this lump is due, it's based upon this amount, these number of units on this assessment, whatever you want to call it, fee. If you bill this amount, this will be what you're due, this is what you have to pay.
In order to obtain the certificates of occupancy,
Right.
yes. So
So if they build half, would they get half back?
Your Honor, if they abandon the project sort of mid-development,
But they just end up building half. They could have built more, but they, for whatever conditions, money, economics, whatever, they decide to stop with half. Do they get half their money back?
Well, Your Honor, they had never paid half the money because the way that the town council,
So there'd be no CO in which to trigger the payment.
yes, Your Honor, there'd be no deadline.
Okay, so they would not owe money on units that were not built.
Correct, Your Honor.
Okay. So halfway through, they wanted to convert it and build out the balance of the project to take advantage of the fee.
I'm sorry, I don't understand your question.
Halfway through,
Yes, Your Honor.
they wanted to say, okay, we need to build some affordable housing because we can make more money by doing that and not paying the per unit fee. Would they be entitled to do that too?
They would need to go back to the town council and get an amendment to the permit. However, that would align with what staff recommended and the purpose of the ordinance, so I don't think they would have had much difficulty getting that change.
But they would not have been automatically entitled to that, is what you're saying. They would still be bound by the original assessment.
Correct. All of the conditions in that development permit would bind their development, should it be built, until a change to the permit was made.
What I think I hear you saying is that once the development plan was approved, they would have to build per that development plan. If they changed the plan somewhere along the way, they would have to go back, or they wanted to change the plan, they would have to go back and get permission to alter the original development plan. Is that what you're saying?
Yes, Your Honor. And I know that's very frustrating for builders all over with all different kinds of permits. But that is generally how it works with development permits. And in this case, they could have built it. They could have passed it to a successor in interest because that permit and all the rights that are vested in it runs with the land. And so once that permit issues, all of the rights in that permit to build that development run with the land, and those conditions also run with the land unless they're changed.
Going back to Judge Carpenter's last question,
Yes, Your Honor.
you have a certain amount of lots, certain amount of units. And you can build the same size house on the same lot. And depending upon the amenities that you would put in that house, you could have an affordable house or a luxury home. You agree with that?
Yes, Your Honor.
So it's immaterial. The same structure on each lot could be affordable, or it could be not affordable. Not affordable.
The ordinance does allow some variation in the structure as well. They're not required to all be the same size as long as they're within the same number of bedrooms and within a certain ratio.
So is it based on what the house is going to sell for?
Your Honor, because developers are businessmen, I assume that they, plan their costs for basically
What
what
is
sell
an
the house.
affordable house in Chapel Hill? I'm trying to answer that question in Raleigh, but I mean, what is considered an affordable house in Chapel Hill?
So this issue is, I believe in the record that the town established the dollar amount for the IZO for the fee in lieu based on the cost of subsidizing affordable housing at 80% of the income level, the average income level in the town. That amount was set in 2010.
So it has nothing to do with the market price of the house, it has everything to do with the income of the potential buyer?
The definition of affordable housing in the ordinance is based on the income of the buyer. The definition of the amount of the fee in lieu is the cost to subsidize a buyer in purchasing a market rate house. That cost is provided, I believe, I'm straying from the record here, Your Honors. I'll keep it to the record.
I was just trying to determine how is the test of compliance with the ordinance gauge? That's what I'm trying to ask.
Correct. So the affordable housing is defined in the ordinance as a buyer at 80% of the area median income, I believe is the language in the LUMO attached to the complaint. That also tracks the language in the general statutes section 41A-4 and 41A-5 when it is permissible for towns to consider affordable housing in development approvals, and that also defines affordable housing as being 80% of the area median income, I believe. It is attached in the appendix to the brief.
Hypothetically, what happens if Epcon Homestead, before they acquire the property, which is our relevant time here, right? Before they acquire the property, they come to the town of Chapel Hill and say, we want to build this development. Chapel Hill says, great, we need 15% affordable housing. And they say, we don't want to do that. You say, well, you can pay a fee in lieu. And they say, we don't want to do that either. What happens then?
There are some alternate means of compliance, but
They don't want to do any of those.
if they don't want to comply with the town's ordinances, the town can deny their development permit.
Okay.
And they can appeal that denial to the Superior Court, and if the Superior Court finds that the town denied the permit based on an unconstitutional condition or an ultra vires condition, they can reverse that decision and remand to the town. And so, Your Honors, we urge this court to find that this case is not an impact fee water and sewer case like Quality Built. This is definitely a case challenging the validity of zoning or development conditions. Per the North Carolina Supreme Court's own words in Quality Built, that means that Quality Built's reasoning does not apply, and rather the more specific statutes dealing with development conditions do apply. That's a one-year statute. It accrues upon issuance of the development approval. Thank you, Your Honors.
Thank you. Any questions? Thank you. Rebuttal?
Yes, Your Honor, just a few brief things. First, I'd like to, you had some questions about the, what it means to build affordable housing, and I'd like to address that because it is dictated in the ordinance. This, as alleged, this property was in the R2 zoning district, so the town's ordinance required 15% of the number of units be what's called set aside for affordable housing. And the town continues to refer to this as building affordable housing. That's not what the ordinance requires. What it requires is, it says at page 32 of the record, the homes that you build have to, for affordable housing purposes, have to have the same exterior appearance. They have to have the same number of bedrooms, right? You're essentially required to build the same house as you're building everywhere else. And so you're not building affordable units, you're building the same units. And what the town requires is that the developers sell those units to identified group of people at certain income levels. That's page 32 of the record, 3.10.
Is there latitude, or is your client given latitude on the level of finishes that they put in those same box, different finishes?
Well, I think the ordinance dictates that the exterior be the same and the number of bedrooms to be the same. I don't know how many, I don't know how much money you're going to be saved building the same sized house under the same building code with the same exterior. I mean, you might be able to put in some different countertops or something like that, but we're essentially talking about the same units here. And it's not a requirement to build affordable units. The requirement is that they be sold to certain groups of people and at a price that's dictated by the amount of their income, 80% of median income. That's 3.10.9 in the ordinance at page 32 of the record. So what we're really talking about is a requirement that they give away their property, the compelled transfer to certain groups of people at below market prices, which is the definition of a compelled transfer without just compensation.
Only if they
And
want
that's-
to build though, right?
Say that again?
It's a choice. It's this, or maybe the numbers don't work and you say, you know what, that piece of property is not going to work for this development. Let's buy another piece or go elsewhere.
Yeah, but that's not an excuse to be outside of constitutional norms, right?
But
The Horn
your
case-
constitutional norms you raised in the Fourth Circuit and they rejected them, isn't that correct? On statute of limitations grounds?
The Fourth Circuit said that the statute of limitations applied to a 42 USC 1983 claim was barred. The Fourth Circuit actually made a very clear distinction between a constitutional injury for which the 1983 claim was seeking redress and the state return of fee claims that are brought here.
But what you were talking about there about compelled
Transfer.
transfer, that's a constitutional argument, isn't it?
It goes to whether it violates the unconstitutional conditions doctrine articulated in Anderson Creek and from the Supreme Court. It goes to whether the underlying fee is lawful. And that's the point I've been trying to make, the difference between arguments which aren't barred by, or claims that aren't barred by statute of limitations versus a cause of action for which statute of limitations apply.
The Fourth Circuit didn't rule on any state constitutional claims either, did it?
No, so I argued in the Fourth Circuit that the federal claims accrued at the time of payment. Same, just like we're saying here with the state law claims. I argued there was no constitutional deprivation until the property was taken. There was no deprivation without due process of law until they were actually deprived of that fee. And the court held that the constitutional deprivation occurs once the government conditions the grant of a land use permit on the surrender of a landowner's right to just compensation. And that's a direct quote from the opinion. So according to the Fourth Circuit, the constitutional injury redressable through a 1983 claim occurred when the permit was issued. But that's not necessarily the same as the current state causes of action for return of fees.
Do you disagree with Judge Rushing when she says there's no continuing wrong doctrine applicable in this situation?
Well, let me address further. I respectfully disagree with the Fourth Circuit opinion. I think I respect it, and we didn't try to take it up to the Supreme Court, and I accept it. I do think there was error there, but the majority opinion makes very clear that Epcon conflates, talking to the Fourth Circuit here, talking about my opinion or my argument up in Richmond, that it says that we conflated the nature of the state and federal law claims. It's in this direct quote, in relying on quality built homes, Epcon conflates the nature of its state and federal law claims. While the essence of Epcon's state return of fee claim is arguably the unlawful fee payments exacted, its 1983 injury was inflicted by the special use permit condition requiring Epcon to set aside part of its property or pay the fee in lieu. Hence, any violation of Epcon's constitutional rights by the town would have occurred prior to when Epcon actually paid the fees. So it was making a very clear distinction between the constitutional damages when that constitutional injury occurred versus the injury for which we're seeking redress through the cause of action arising under state law.
I'll give you a moment to sum up.
Thank you, Your Honor. If the court, and the one last thing I'd like to address is the point about the petition for writ of certiorari that the town now claims that we should have brought. It didn't argue that in the trial court, and in its opening brief on page 3 in a footnote, again, stated that it wasn't raising that issue here on appeal. So to hear it again today, it was kind of surprising. The fact of the matter is that the ability, to Judge Carpenter's point, is that if we came in and said, no, we're not going to set aside affordable housing units, we're not going to pay a fee, we're not going to do any of that, the permit would have been denied. And the argument that we're making here today could not have been dealt with through a petition for writ of certiorari, right? Because at that point, we're talking about the underlying lawfulness of the ordinance and the scheme, not any decision-making by the town council. The town council was compelled in a quasi-judicial capacity to follow its ordinances, not determine whether they're lawful. So the argument we're hearing today for the first time in connection with this motion that this was somehow should have been dealt with a petition for writ of certiorari, I think is wrong. So I respectfully submit that this case follows the many before quality built homes and its progeny. The claim accrued, the claims are subject, the causes of action are subject to 3-year statute of limitations that accrue the time the various fee payments were made. and respectfully ask this court to reverse the trial court.
Thank you.
Thank you.
Thank you.
Thank you very much.
The case is submitted. We appreciate the good arguments of the counsel. And Madam Clerk, you may adjourn court.